And welcome back, everybody, to the Law and Crime Network. You were just watching some of the rebuttal from the prosecution's closing in the Tex McIver case. And of course, we are in verdict watch. That verdict could come in any minute. We're very closely monitoring what's going on in a courtroom in Atlanta, Georgia, as we are all very anxious to see how the jurors are going to decide this case. Do they think prominent Atlanta attorney Tex McIver is guilty of murder? Is it involuntary manslaughter, or are they going to be hung on this? Or not guilty? We'll see. Gary Gerstenfield's on the line with me. Gary, criminal defense attorney, tell me what you made of these closings. We were just watching the prosecution's rebuttal there. Very animated rebuttal, I will say.
Well, he's doing what he can with what he's got. This is a challenging case for the prosecutor because, as something that you all have been talking about, and I think doing a great job about, is the comparison between this case, in some ways, and the O.J. Simpson case, where the Christopher Darden asked O.J. to try on the glove, and of course the glove didn't fit, which became the entire narrative for the defense in the closing, the famous lines, if the glove doesn't fit, you have to acquit. Tex McIver's attorneys are not quite as stylish as what O.J. Simpson had, but the message is still the same, which is, hey, if a trained deputy can inadvertently fire this gun, certainly it is reasonable that Tex McIver would do the same thing. So it's that same moment. You get these aha moments as a defense attorney, and sometimes aha moments as a prosecutor, where you.
Gary, we lost you. We're going to try to get you back because you were saying some really important stuff. In the meantime, as I mentioned, Gary's back. Gary, sorry, we lost you just for a second there. You can continue.
Okay, where did you last get?
You were talking about the analogy with the O.J. Simpson case.
Yes. Well, it's something there's an obvious parallel. And so in the O.J. Simpson case, there was a definite aha moment. And that aha moment is when Christopher Darden has O.J. Simpson put on the glove, and of course O.J. Simpson struggles to put on the glove, and it becomes clear that the glove doesn't fit. That becomes the whole narrative for the defense, which is, of course, if the glove doesn't fit, you have to acquit, which is now part of our popular lexicon, and we use that all the time as a sort of a comical remark whenever something becomes impossible. Hey, if the glove doesn't fit, you have to acquit. Well, here in Tex McIver, he has attorneys that aren't quite as stylish as what O.J. Simpson had, but still, there was that
come on, they're pretty
moment
stylish, but keep going, yeah.
But you had this aha moment where the sheriff's deputy attempts to handle the gun, and inadvertently the gun fires. There's no bullet in it, but still we hear the click. It's inadvertent, it's unintentional, and that drives home the entire defense narrative. Hey, if a trained police officer here in a courtroom with all the safeguards and all the assurance that we possibly can provide, and in this situation a deputy could inadvertently trigger this handgun, certainly Tex McIver, who was asleep, who wakes up, who's in, it's, again, we've heard this thing about this in between sleep and awake arousal moment, and then he takes the gun and the gun inadvertently goes off. It's almost as if the prosecutor's own witness made the defense argument.
Well, and we kind of called it, not to pat our own back, but when we saw that moment happen and kind of realized what had happened, we said you can guarantee during the closings the defense is going to play that video and play that video over again, and they did. So as we get to the conclusion of this, we're on verdict watch. It's a little bit more complicated, right, for the jurors, because they have to decide between that murder charge but also some lesser includeds. How do you see this coming out?
Well, I think Tex McIver's biggest problem that he has is probably things that happened after the shooting at the hospital, and perhaps some of his conduct, particularly with his wife's best friend, some comments that he made there. There are some vulnerabilities that the defense has that I don't think they've completely been able to resolve. That being said, I think that the overall tenor of the case is that defense is in a very good position.
I think you're absolutely right. Most of the legal pundits we've had on our show say they are, but I got to tell you, we've been covering cases, and I've been covering cases for a long time, and you just never know what the jurors are going to do. You can, from an outside perspective, watching it on a live stream or even from inside the gallery, you watch this case, but when you're in the juror's box and you're reviewing in that deliberation room the evidence, it comes down to the dynamic of the jurors. So many different things are in play that, you know, I'm just not surprised by anything at this point.
You know, you're absolutely right. Years and years ago, when I was a much younger attorney, the prosecutor and I finished a trial. It wasn't a very serious case. And we neither one of us had ever been part of a jury, never heard deliberations. We both really wanted to kind of find out what a jury talks about. And so we kind of, a bailiff stands in front of the, or actually sat in front of the door to the jury room. And so, you know, you can't, you know, the idea is to give privacy to the jury. But there was
Okay, we lost Gary again there.
Oh, okay. In that room, there's nobody guarding it. And so the prosecutor and I thought maybe we could just kind of stand over there and just kind of maybe eat our lunch and just kind of quietly hang out. And maybe while we were sitting there unobtrusively, we might have overheard everything the jury said. And it was fascinating because we both knew the facts of the case so well. We both knew
are you allowed to do that, Gary?
I know. This is more than a decade ago, and I don't remember what courthouse it was and who cares. But the point is, we knew the case. We knew the facts, and we listened, and we weren't listening to everything. But the point is, the jury took off on a completely different thing, and that's the point. Juries start talking, and when they start communicating with each other, and they start thinking about what happened and what ifs and what ifs, they're not lawyers. They're listening to the facts of the case, and they're applying the facts to their own experiences. And those experiences can be so different and wild that the facts of the case then sort of take on a life of its own and ends up going in all sorts of directions. And the point is, we don't know, and that's the point. You never know what a jury's going to do because with 12 people talking, just like the movie The 12 Angry Men, people get into their own narrative, their own discussions, and then from their own optics, and we don't know where it's going. And of course, you know, you think that you've got the case nailed, you think you're going to win, and then you come back and the verdict surprises you. And in this case, we don't know is a good point.
Absolutely, Gary. Well, I'll tell you what, we are all monitoring what's going to happen in this Tex McIver murder trial. We're on verdict watch. We have a pulse in the courtroom. As soon as we see any action, we will bring it to you here live. In the meantime, I think it's important that we continue our review of the closing arguments from yesterday, specifically the prosecutor's rebuttal. It got a little fiery. He was very passionate. Let's take a listen to the rest of that. Welcome back, everybody, to the Law and Crime Network. You were just watching the rebuttal by the prosecution during closing arguments in the Tex McIver murder trial. It is, we're really counting down the minutes now till we get this verdict in. The jurors have been deliberating now all day long and a couple of hours yesterday. This verdict could come in any minute. I'm here alongside fellow host Aaron Keller, as well as Gary Gerstenfield, who is on the line. Let's talk a little bit about the prosecution's rebuttal. Mr. Rucker, he was very enthusiastic. He was very passionate. What'd you make of it, Aaron?
I said before that I give him an A+ on theatrics. This guy's got great command of the courtroom, probably better than anyone else we've watched in recent memory.
I agree.
But I give him about a C- on logic, because so many of these points just don't add up to intentional murder. And that's the top charge that the state is trying to prove here. For instance, this whole situation that we just heard, why did Diane McIver say she didn't want to talk to her husband? Well, it wasn't because she thought that he killed her. She said that she thought it was an accident. The reason she probably said, no, I don't want to talk to my husband, is because she wanted the treatment to get underway.
Right,
she knew she needed to be treated.
So this was the prosecution's theory. Of course, she was in the hospital. It was a dire situation. She was dying. And a doctor or nurse, I guess, asked her, do you want to see your husband? She said no. Prosecution, in their rebuttal there, tried to use that as, as evidence somehow of murder. Gary, what do you make of this?
Early resolution docket.
Well, I completely agree. I mean, the main points that Mr. Rucker raises, he uses Dr. Sellers as sort of a truth detector, saying, you know, this isn't grief, this is greed. I don't think that's Dr. Sellers' job, and I don't think the jury's going to be impressed by that. He makes a comment about there being about Tex McIver being greedy, being a liar, and being all be guilty of, but that, so what? Probably the most important comment Mr. Rucker made, and I wrote it down, is in talking about Tex McIver, he says, it doesn't mean he didn't intend to intentionally kill his wife. And the emphasis is he didn't mean, it doesn't mean he didn't intend to. In other words, what he's saying is, look, he says he didn't do it, but he might have. He might have intended to. And that's the last thing you want to say when you have the burden beyond a reasonable doubt. There shouldn't, you're a closing argument. This is your last shot with the jury. You get to go last because you have the burden. And with that last shot, you want to be any equivocation whatsoever. And I thought it was interesting that despite, and I agree with Aaron, despite the strength of Mr. Rucker and the way he commands the courtroom, that comment, I think, more than anything else, emphasizes his own awareness of the weakness he has in his case.
Well, and also it's kind of a double negative, which is kind of confusing to the jurors anyway, because you have to parse through what exactly does he mean by that. But the fact that he even said that, like you said, I mean, raises all sorts of reasonable doubt in the juror's mind. Aaron, what did you make of that particular comment? I think it's really interesting that Gary picked up on that.
I mean, it was sort of a capstone on every other issue that existed in the case. And look, I mean, I've said before, and I'll say it again, in my opinion, a lot of things just look really slimy about the way Tex McIver functioned in this case. The telling Danny Jo Carter to tell people that she showed up to support the family, not that she was driving, that does not look good at all for this guy. And look, I acknowledge that. But why did he do it? It may have been because he was just under the pressure of a situation spiraling out of control, and he was trying to protect her from what he presumed to be the onslaught of press attention, which, lo and behold, Danny Jo Carter said hit her, and she did not in any way appreciate. Of course, then again, why did it hit her? Well, in part because of some of this other stuff that he basically asked her to do. Some kind of witness tampering charge, that influencing witness charge. Could that charge stick? Yes. Is this a negligence case, criminal negligence? Could that charge stick? Yes. And originally, that's what prosecutors went for in this case. Those charges, if the jury comes back and convicts on those charges, I think that this jury did a great thing. I can see those convictions sticking because the facts and the law mesh. Intentional homicide beyond a reasonable doubt, I don't see that fitting.
Another thing, too, where I think the prosecution lost some credibility was this whole issue with this woman by the name of Annie Anderson, who was the masseuse, massage therapist, whatever you want to call her job title, where, you know, the prosecution kind of went into this insinuating that she had some kind of sexual relationship with Tex, trying to make that kind of murky, that he was this awful person, that right after he offed his wife, he went off and had sex with the masseuse. And then she got on the stand and unequivocally denied it, and I think her denial was pretty believable. And then the prosecution kind of walked back that whole theory. Gary, what do you make of that?
Well, again, you know, prosecutors sometimes what they do is they take a shotgun approach, and it sometimes can blow up in your face. But what they'll do is they'll say, okay, we don't have clear intent. I mean, this, again, is a strange place to shoot your wife, backseat of a car with her friend Mary Jo, Danny Jo Carter driving the car. It's just a strange place at this point to intentionally want to kill your wife, particularly when you're back at the ranch, there's guns, there's a place to go shooting. If you place to do it. So already they've got a problem on motive, and they have a problem explaining it. Of course, you know, the deputy misfiring the handgun. I mean, you'll never get away from that in this entire case. But at that point in the trial, yeah, they're trying to throw anything they can up, and what they're looking for is consciousness of guilt on the part of Tex by behavior that he does post-shooting. And so they're just looking for anything they can say, look, this is strange behavior, only a murderer would do this. And, you know, only a murderer would get a massage, only a murderer would be in a bedroom with a woman. Clearly, this guy's guilty of killing his wife. I mean, how far you can take that. In closing, the judge gives you a lot of latitude, and clearly this court's allowing that. That being said, when you shoot a shotgun and you miss, and it looks like you're just shooting at anything, the jury sometimes takes that, well, you're shooting at nothing.
Well, and you got to this a little bit, what you were just talking about, and the prosecution trying to say that how Tex McIver reacted to the death of his wife and what happened as proof of guilt is something that irks me both ways when the prosecution tries to do it and when the defense tries to do it. They try to say, oh, well, if he was really upset, if he was really grieving, he would have acted this way during that police interview with Atlanta police. I never buy it for the defense. I never buy it for the prosecution. I think when you resort to that, Aaron, that you're kind of desperate.
I agree. Look, I mean, everyone grieves in a different way. People sometimes shut down. They want to be alone. Some people want to be around everyone. Some people don't want to be alone when they're grieving. Some people do. And to try to characterize or shoehorn every person into the way Hollywood actors and actresses make grieving look just does a disservice to simple psychology, and it does a disservice for justice. Everybody grieves differently. People in my family have grieved differently when they've lost relatives at different points in their lives. So whenever somebody goes that way, I agree with you, Rachel. It's stereotyping, and that doesn't help.
And it also shows a bit of desperation. Okay, so as we continue to wait for this verdict to come in, we're going to stand by and keep a very close eye in the courtroom. If we see any activity, we will take you straight there. In the meantime, I think as we wait, it's critical because I guarantee you the jurors are now doing this, reviewing the testimony of what I would say is the prosecution's key witness, and that is Danny Joe Carter, the friend of Diane and Tex, who was driving the night of the shooting. Let's take a listen. Alrighty, we just got, it was not a verdict, everyone. We just got some juror questions. 3, in fact, but I think Aaron and Gary, who's on the line with me, will agree number 1 is the most kind of important one and gives us some insight on to what the jurors might be thinking. And they asked, can we find him not guilty on counts 1 through 4, which are, of course, the most serious of the charges, including that murder charge, and find him guilty on count 5. Count 5 is the witness tampering charge. Aaron, what does that mean to you?
Well, it means at least one juror is thinking about saying the only thing that the state proved beyond a reasonable doubt is that he asked Danny Joe Carter to lie about her position as the driver of the vehicle, and that at least one juror who's asking that question might want to acquit on all the other charges except for that influencing a witness charge, which is basically what we've been sitting here saying all along, that that's the strongest charge that the state has got.
The jurors are not allowed to watch Law&Crime streaming, but they might have been because, like Aaron has been saying, that's exactly what many of our legal pundits have been saying. Gary, what do you make of this? I think it's a pretty big deal that they asked that question to the judge.
Very much so, and it's a nail-biter for the defense because, of course, they want an acquittal across the board, and so it's sort of a mixed message. And the good message, it sounds like, is the main murder charge. It sounds like the jury's through 4, and now we're stuck with this tampering. And the seriousness of this tampering could
Jerry, you know what? We're going to try to work
him.
on some of the technical issues. Your connection's just not so great, so we're kind of getting every other word. But I do agree with Gary here that I think that this is a pretty big deal. An interesting moment just happened in court as we were watching all of that. I mentioned earlier that Paul Howard, the Fulton County DA, was there. He whispered, Aaron, and you caught this too, in the ear of the prosecutors. Okay, you know what? We'll get to that issue in a second. Let's take a listen to what's going on in court. The judge is talking. Okay, we have a live shot right there. That is Tex McIver, the defendant. Kind of important moment here in the jury deliberations. The jurors had 3 questions, and the judge just told the attorneys what his answers are going to be. One particularly important one was when the jurors asked, or at least one juror wanted to know, could they find him not guilty as to counts 1 through 4, which of course, folks, are the most important, I guess you could say, murder charges, the aggravated assault charge. Could they find him not guilty of those charges and only find him guilty of count number 5, which is the witness tampering charge? Aaron, it looks like they are done there in the courtroom. Deliberations are probably going to go for another half an hour. I'm guessing we're probably not going to get a verdict tonight based on the fact they want to go into the car and take the gun in the car. Oh, would you expect a verdict tonight?
I would be shocked if we get one tonight, because it seems like there are some outstanding questions that at least some members of this jury need to have answered. They want to look at the trajectory of this thing, because again, one of the insinuations here by the defense is that the way the gun was held, if it was held upright, the barrel is higher than the trigger, and they might want to get in there and look at the distances and say, look, does the gun look like it was upright in an actual shooting position, the way Danny Joe Carter remembered it being held? Is it possible that he fell asleep with it that way? Is it possible his elbow was back further than it was in some of the reconstructions, the computer-generated reconstructions that the state showed? They want to get another look at this. So somebody might be thinking the state's theory is plausible. But that question number 1 would suggest that at least one person is thinking that the state's theory is junk, that it doesn't hold up. You know, and then the emails, they probably want to get into the wording again. Maybe somebody wants to make a point to a fellow juror and say, hey, look at the wording of these. Look at the date of these. The wording might favor the prosecution. The date might favor the defense. An argument 5 years ago before shooting happened, is it really relevant? They want to hone in on these details. And I would guess that maybe these questions are being asked by different members of the jury, because they almost seem to be
a little disjointed,
a little bit opposite. In other words, is one juror thinking acquittal on the serious charges, and is another juror thinking guilty?
Yes and no, but at the same time, you know, if he doesn't, if that one juror didn't think that's where perhaps the rest were leaning, it would be kind of a moot point to ask the judge whether they can acquit on the more serious of the charges and just find him guilty of count number 5. It also says to me, if we buy into that possibility, that perhaps we have a hung jury in our hands here, in that, you know, the fact that they are asking some of the more serious questions, wanting to go back in the car with the gun, that leads me to believe, are they still questioning the murder charge? At the same time, we have some other jurors totally casting that aside, the more serious charges, and looking at witness tampering. So based on these questions, if I was predicting, if I were to predict what would happen, I think you've got one of 2 scenarios. One being that they acquit on the more serious charges, find him guilty of count 5, which is the witness tampering, or you have a situation where you have jurors that are hung, that can't decide, that can't come to a conclusion about this.
I agree 100%. Okay, so what happened in court right there was, when that first question was read, Tex McIver and his team were already envisioning their celebratory party. Okay, and then when that second question was read, they're just like, wait a minute, we might need to sweat this out a little bit more. You can sense that the tension in this case ratcheted up 2 or 3 more notches, because these questions could be interpreted to mean there are a couple of competing factions back in that room. Or, okay, as you said, a second scenario is maybe they want to get back in the car just to make sure they didn't miss something. Maybe they all agree that counts 1 through 4 are garbage.
But then
they're ready to acquit.
See, here's the weird thing about that. If they thought counts 1 through 4 were garbage, the murder charge, the ag assault charge, then they wouldn't need to go back in the car with the gun.
Unless they want to double check themselves, unless they're being so careful to say, you know what, gosh, we don't see this, but did we miss something? Did we look at this the wrong way? They might want to get another look at these just to make sure that all the I's are dotted and the T's are crossed, and the theory that question number 1 at least suggests is one of the theories that's being floated. And look, we were saying before, these questions mirror almost perfectly what we've been seeing here. I don't think that in any way is because some member of the jury is sneaking and watching. What it is, look, what it is a bunch of rational people looking at the law the same exact way.
The evidence that we all are.
If you see a stop sign and I see a stop sign, we're not going to disagree about what we're supposed to do when we pull up to it. We're going to look and say, well, we both need to stop. That's what's going on here.
So bottom line, if I'm sitting at the defense table right now and I heard those jurors' questions that we all just heard, specifically question 1 about acquitting him on counts 1 through 4, even if it's a total, even if they do find him guilty on count 5, witness tampering, which could only, by the way, result in probation, possibly not even any prison time for Tex McIver, I'd be sitting pretty happy. But again, you never know until the verdict's in. So as we continue to be on Verdict Watch here on the Law and Crime Network, I want the viewers to continue to carefully watch that testimony from the key witness, Danny Jo Carter. We've kind of gone through her testimony before, but we want to show it to you again because like we said earlier, this is really, I think, where the jurors could get hung up in this case. Let's take a listen. And welcome back, everybody, to the Law and Crime Network. We're now taking you live inside the McIver courtroom. Jury deliberations are ongoing. Let's take a listen. The judge is talking.
From 147 did they get, but then we'll have answers to both of those inquiries in the morning. Any issue with me doing that with the jury in your presence, state?
No, just want to let the court know, logistically we have worked it out.
We're not taking that personally. You were saying, Mr. Rutter?
Logistically we have worked out the fact that the vehicle will be here tomorrow at 9:30 if they so request. And the court is inclined to allow them to be there with crime scene technician Tropic, who will be here and available with the Dow.
He's a dependable guy.
Yeah.
Okay. All right. Any issue, Mr. Samuel, with me relating that to the jury before they go? Okay, great. Let's bring the jurors in, please. Is 147 still circulating out there? Okay, great.
Okay, no exciting action right now in the Tex McIver murder case. It looks like the judge, after a full day of deliberations, is sending the jurors home for the day. They'll return tomorrow morning at 9 o'clock in Atlanta to begin deliberating again. But we got a little indication of where this case might be heading by the juror questions that we had there at the end of the day. Aaron, what do we make of those?
Well, I think the big question was question number 1. The question was, can we find the defendant guilty on charge number 5 if we find him not guilty on charges 1 through 4? Well, 1 through 4 were murder, felony murder, aggravated assault, and a weapons charge. Charge 5 is the witness intimidation charge, the least serious of the charges and the easiest to prove on the facts we have. What's interesting is the way the defense jumped in and tried to correct the way the judge wanted to answer it. The judge wanted to answer the question by rereading the original charge to the jurors, the answer being, can we acquit on 1 through 4 and convict on 5? The judge wanted to say you can convict or acquit on all, some, or none of the charges. In other words, anything can happen. The defense is like, no, I just want a simple yes.
Well, I think the bottom line here is the jurors were a little confused. They're thinking to themselves, perhaps, okay, I do not think he's guilty of these more serious murder charges, ag assault charges, but if I don't find him guilty, if that wasn't a crime, then can I find him guilty of witness tampering? And the answer is yes. And I think that this was kind of a critical moment in the deliberations because it's giving us an indication that maybe just one juror, but maybe more, are thinking that perhaps this is a case of, we're going to find him not guilty on it, the very least, the murder charges.
Yeah, okay. And some people are saying, well, that could just be one juror. Well, look, if that juror is firm in his or her opinion, even if the rest of the jurors are against that juror, it results in a mistrial here on those top charges. So reasonable doubt is about sowing a reasonable doubt in the mind of at least one juror who is convinced of his or her opinion. So if this deadlocks things, that's a signal to the state that the state oversold the case, overcharged the defendant, and if the state goes for a second trial, sometimes they have to dial back.
All right, it looks like we have a jury question. We thought that the judge was releasing the jurors for the night, but let's go right into that courtroom right now in Atlanta. All right, it is the end of deliberations in the Tex McIver murder case for the day. They'll be back again tomorrow morning at 9 o'clock. We did get one additional question from the jurors, Aaron, and that was, can we see Tex's APD interview, his police interview? They want to see it tomorrow morning. What does that tell you?
Well, that interview is pretty wide-ranging. So if we're to read it in conjunction with the other questions, it could suggest that jurors want to hone in on the way that he said he was holding the gun. Because remember, he sort of indicated in his hands how he thought his hands were sitting when this whole thing went down. The state has tried to debunk that. And maybe if they want to watch the recording and they want to get in the vehicle, maybe somebody on the jury or a number of jurors are trying to figure out if the trajectory from themselves sitting in the seat matches up with what the defendant said. Maybe. That's just
well, it's certainly very interesting. We're going to keep a very, very close eye on the Tex McIver case. We'll be back tomorrow morning at 9 o'clock. We're also following another case out of Florida, so we'll have live testimony from that as well. So please stay tuned. For now, we're going to say goodbye and have a good evening.